A courtroom judge warning a defendant about removal. A former president visibly losing composure. An insider breaking years of silence under oath. These three elements converged in a single moment that legal observers will analyze for years to come. Hello, everyone. This is David Muir, and welcome to the CG News. If you value serious legal analysis without the noise, please hit the like button, subscribe to the CG News, and share your perspective in the comments below. Your engagement helps us continue delivering in-depth coverage of the stories that matter. Less than 1% of criminal trials involve a former president. Even fewer feature a judge openly warning that removal from the courtroom is possible. Yet that scenario unfolded before a packed jury, creating tension so palpable that veteran court observers were visibly surprised. This was not standard legal procedure. It was a moment that demanded attention and raised an immediate question. What exactly transpired inside that courtroom? The catalyst was not a document, a technical motion, or a procedural disagreement. It was testimony from someone who once stood in Donald Trump's inner circle, someone who witnessed private moments and observed decisions made away from public view. Under oath, this witness delivered statements so unexpected and damaging that Trump's reaction became impossible to ignore. The most striking element was not the content alone, but the source. This witness was not a political adversary, a journalist, or a distant bureaucrat. He was someone from within Trump's closest circle, a person who spent extensive time in his presence, managing sensitive matters, witnessing private behavior, and observing how choices were made when cameras were absent. In trials of this significance, insider testimony carries exceptional weight. Jurors instinctively recognize that proximity creates knowledge and knowledge carries authority. There is a fundamental difference between speculation and hearing from someone who is physically present. What amplifies the impact is the question of loyalty. People close to powerful figures rarely speak publicly. They often remain silent for years because breaking that silence involves real social, financial, and legal consequences. When someone who once enjoyed trust suddenly testifies under oath, jurors ask a simple but critical question. Why would they risk everything? That question typically leads to an uncomfortable conclusion. At some point, staying silent became impossible. From a psychological perspective, testimony from a former loyalist often feels more credible than accusations from known opponents. Prosecutors understand this dynamic thoroughly, which explains why Trump's visible reaction carried such significance. Losing credibility to a stranger is frustrating. Losing it to someone who knows your habits, routines, and private reactions feels deeply personal. The impact was magnified by how the testimony was presented. The witness did not rely on rumors, assumptions, or secondhand information. He did not use phrases like, "I heard" or "someone mentioned later." He looked directly at the jury and made one fact unmistakably clear. He was present. He witnessed events firsthand. That distinction fundamentally changes everything. Eyewitness testimony cuts through legal complexity because it provides jurors something concrete, a real person describing a real moment as it happened. Most high-profile trials depend heavily on documents, emails, timelines, and expert analysis. Those elements matter, but they can feel abstract. Eyewitness accounts are different. They create mental images. Instead of studying paperwork, jurors imagine the room, the timing, the behavior, and the decisions being made. When a witness speaks calmly, confidently, and without exaggeration, those images become remarkably powerful. Prosecutors recognize that moments jurors can clearly visualize will remain with them far longer than any chart or legal argument. This is also why the testimony proved so difficult for the defense to challenge, and why Donald Trump appeared increasingly frustrated as it continued. Legal arguments can dispute intent or interpretation, but it is far harder to explain away a witness who states simply, "I watched it happen." To discredit such testimony, the defense must often suggest outright dishonesty. That becomes risky when the witness appears composed, detailed, and has little to gain. What made this testimony particularly damaging was a shift from accident to deliberate action. This was not a narrative about misplaced paperwork, forgotten storage boxes, or staff errors. The witness described actions that appeared calculated, purposeful, and intentional in a courtroom. That distinction is enormous. Jurors may forgive confusion. They may overlook carelessness. But intentional behavior immediately raises serious concerns because it suggests awareness, and awareness fundamentally alters everything. The